People v. Jennifer Crumbley, case number 22-279990-FH.
Good morning, Your Honor. Karen McDonald appearing on behalf of the people.
Thank you, Mark Keeston on behalf of the people.
And good morning, Your Honor. Shannon Smith on behalf of Jennifer Crumbley.
We're all here. Let him go.
Okay, my question, I'm asking the court when there's an objection, if we can all slow down, and if I'm objecting to the prosecutor making these speeches on the record that go in front of the jury.
Well, what speeches are you talking about?
Yesterday, during the questioning, when Brian Maloche was up, the prosecution, when they would object, they would start to just say,
well, I guess the first thing, and you guys, in the heat of battle, people forget this, even though they know it, that you can't make a record if people are talking at one time. But there should be a legal objection and a response to it. Things kind of went sideways yesterday because I think that the prosecution was saying to you, Ms. Smith, you may have opened the door. I think it's already open. Are we going there? So I think their intention was to warn you, stop you, or let you know that if you were going to go there, they were going to go there. So I really think the prosecution was making a statement or interrupting you for the purpose of wanting to comply with my order excluding certain evidence. So, things got a little crazy yesterday. So.
Your Honor, I believe it was beyond that issue and it was on other questions, and I'm going to tell the court, I did the same thing at points, and looking back at the tape, I said things, I just would ask we to slow down with objections, and that neither side say things that should not be put on the record in front of the jury.
Okay, so objection and a response.
Thank you.
All right.
So as we went through exhibits 348 to 400 yesterday, we stipulated them, but I don't think they were formally admitted, so I just moved for the formal admission now. They're the photographs from the witness.
Yeah, no objection.
Did you receive my email about the sealed record?
Yes.
Yes, sir.
Okay, so I want to do that not while the jury is waiting, and it won't take much time. Sorry, I'm looking for my exhibit list. So, I'm sorry, Mr. Keese, you're moving for the admission of exhibit.
There were 348 to 400. They were agreed upon by defense, but I don't think they were formally admitted by the court. I just want to make sure the record's clear.
Yeah,
I neglected to ask for their admission, Your Honor.
Yeah, I think there was sort of an understanding. So 348 through 400, Ms. Smith, I need to.
Yeah, I made no objection, and I did have down they were admitted, but either way, there's no objection.
Okay, 348 through 400 are admitted. I have a lot of paper on my desk, so I suspect that's where my exhibit list is. Anyway, are you ready for the jury?
I believe so.
Yes.
Who's the first witness?
Lieutenant Willis.
Lieutenant Willis? Okay. All right.
Judge, we will be playing a portion of the Oxford High School surveillance video. I'll let the court know before
Okay.
to also inform the victims in the courtroom and so the media is aware.
Yeah, the media's been very cooperative, so I'm sure the victims would like a heads up too.
Of course.
And Your Honor, on that exhibit, the court knows I objected. The court's made a ruling. Can we just not move for objection in front of the jury so I don't have to tell them I've objected? We know it's admitted.
Oh, you don't want to object? Are you saying you don't want to object in front of the jury?
Yeah, because it's already been admitted.
Oh, I understand. So your objection is noted for the record.
Thank you.
Okay. Ongoing objection to it.
Right, thank you.
All right.
All rise for the jury.
Good morning. You may be seated. Thank you for being so timely. We appreciate you. I'm going to ask the prosecutor who the next witness is.
Lieutenant Timothy Willis.
Could you raise your right hand. Do you swear or affirm the testimony about the other truth so help you God?
I do, Your Honor.
Okay, please step up to have a seat. And then would you please state your name to the record?
Timothy Willis, TimothyWillis.
Go ahead, Pastor.
Thank you, Judge. I just need to make sure this is connected.
Is this on, Judge?
What's that?
Is this on?
That usually is last. That usually is on last.
Thank you.
Let's hold on a second.
Is the screen on, sir?
Yes.
Yeah, it's the last thing that goes on usually.
May I proceed, Judge?
Go ahead.
Sir, how are you employed?
I'm a detective lieutenant with the Oakland County Sheriff's Office.
What is a detective lieutenant?
My duties include I'm one of two detective lieutenants in the Investigative Forensic Services Division. We offer support services through investigations to our agency and really law enforcement in the region. My duties include the Special Investigations Unit. I'm in charge of that. I'm in charge of the Fugitive Apprehension Team. I'm in charge of the Computer Crimes Unit, and I'm in charge of our Warrants Unit.
Okay. And we've heard about the Special Investigative Unit through Sergeant Joseph Bryan. Does that individual work for you as well?
He does.
Okay, so specifically the Special Investigative Unit, can you tell the jury what they do?
So the Special Investigations Unit handles major crimes for our agency. We often get requests from other agencies to assist with their crimes or handle them. These crimes range from high-profile cases, political cases, whatever really they kind of request. Our training is pretty expansive in as much that we handle like larger complex cases.
Okay. And how long have you been a lieutenant?
Since 2016.
Okay. And all told, how long have you been a police officer?
I hired in 1996, so I'm approaching 28 years.
All right. Sir, I'd like to direct your attention to November the 30th, 2021. Do you recall that day?
I do.
Were you notified of an active shooter situation at the Oxford High School?
I was actually at the prosecutor's office discussing another totally separate matter, and the prosecutor and her chief assistant came in and advised me, was I aware that there was a shooting at the Oxford High School, and I was not at the time.
Okay, so you were meeting on a different case completely?
Yes.
Okay. And do you recall approximately the time that occurred?
It was around, understand it was a very difficult time to remember exactly, but it was around 1 o'clock.
Okay. And what did you do when you were notified?
Prior to that, we had recently had a similar, but it was a false alarm incident at a different school. So my initial thought was this was another one of those, just someone pulling an alarm or something happened. I immediately collected my things. I got up and walked. I made a phone call. For the life of me, I've been trying to remember who I called. I cannot remember. I do remember them telling me it's real.
Okay. And when you were told it's real, what clicked in with you? I went downstairs. Okay.
Excuse me.
Take your time.
Thank you. I went downstairs and immediately got in my car and went lights and sirens to the scene.
Okay. When you say lights and sirens, what does that mean?
My vehicle is an undercover vehicle for all intents and purposes, but it is equipped with lights and sirens to respond to different things. So, police term, we call it coding. It's just like when you see cops racing to the scenes. It was very similar to that, except my car is an undercover type vehicle.
Do you recall how long it took you to get there?
It was somewhere within 20 minutes, I believe it was.
Okay. Do you remember the drive at all?
I remember portions of the drive to the scene. If you're familiar with the area, M24, Lapeer Road is the major route that we took to get there. It's the major road to get there, and it was completely lights, sirens, cars, just flooding northbound on Lapeer Road, and it was chaos.
So I'm going to show you what's already been admitted as equals 5. This is a map of the Oxford High School. Can you see that on your screen?
I can, sir.
Okay. Can you tell me what you observed when you first arrived at the school?
I observed when I came, there was students leaving the school. There was police officers flooding into the school. Emergency first responders. I know some of our people came right from their home address. It was I remember being shocked at, I live in a neighboring community, and I was just shocked that we have that amount of resources in a northern Oakland County school that quickly. Because I really moved to get there. By the time I was there, people were just flooding that place.
Do you recall where you went? First of all, let me ask you this. Did you go inside the school?
I did.
Okay, when you went inside the school, what was the situation?
I have no recollection of where I parked exactly, but I know I went in through the front office area. You can see on the right there where it says office.
Okay.
That entrance on the south there.
So this would be the main entrance to the school?
Yes.
Okay.
Captain Todd Hill, he was then a lieutenant, had already set up an incident post, an interior post. Understand, we had a perimeter all secured. We were securing all the doors, no one in and out unless you were law enforcement or emergency first responders. And we set up, because it was so cold that day, it wasn't ideal. However, the area where we were at, we determined to be relatively safe. So all of us responded to that area to start handing out our assignments. We refer to that as the interior command.
Okay, so you said incident command, interior command. Tell us the difference.
I'm sorry. So the interior command is just the location on the interior. Incident command is where most, if not all, the decisions are made. So at the time, the incident commander, Captain Hill, his focus was casualties, safety and security of the building, and searching for additional shooters. When I was driving to the scene, I do recall them saying, we were getting tips from, imagine being a civilian, driving around and seeing cars fly by you, hearing about a shooting. We got tips just flooded into our 911 center about, I think the shooter's in this car. I think the shooter's in this car. There's a man in a camouflage jacket running through the gravel pit. We think that's a shooter. So it was just, all we knew to do was go to the school first. We had no idea what else, if anything, was going on. So the exterior command was set up to first to protect the school. The interior command was set up to handle the issues going on within the school that, for lack of a better term, were most known at that point.
Okay, so you were a lieutenant at the time?
I was.
Okay. And at the time, you were also in charge of the Special Investigative Unit?
Yes, sir.
Okay. You said Lieutenant, now Captain Hill was focused on the active scene. So
Yes, sir.
Clearing and casualties, things like that? Okay. What was your focus then?
So immediately upon entering the thing, I had a brief conversation with Captain Hill, advised that I would be handling the investigative portion of this, and we started then devising a plan, the best way that I could participate in the active investigation while the other stuff was going on. There was so many tips, if you will, social media tips coming in about this, that, and the other that, a lot of them certainly proved not to be true, but they had to be vetted. So, I could not just go in and start investigating the scene. There was several opportunities, i.e. For us to interview. We heard victims were at hospitals that needed to be interviewed. There was obviously tons of staff, personnel, and students still on the scene that we wanted to talk to and discuss and try to figure out what had happened.
Okay, so would it be fair to say that it was your responsibility to coordinate this investigative effort?
Yes, sir. So my job, that's exactly what my job is. My job is to direct those resources to the follow-up investigation.
Would it be fair to say that you are the officer in charge of this case?
Yes, that's fair to say.
Tell the jury, please, what does it mean to be an officer in charge?
So, as I stated earlier, I direct the investigation, meaning identify and attempt to interview or have my team attempt to interview victims, witnesses. I assist. You saw Bob Catellis up here from the crime lab. Him and I worked together about obtaining what evidence we deemed was going to be necessary for this case. I direct officers, to secure I directed the officers to secure the Crumbley home because we learned where the shooter lived. At the end of that, I comprised the information, and then I turned it over to the prosecutor's office, and then we discuss charging decisions.
Okay. And that's what an officer in charge does in every investigation.
That's right. This investigation was not unique to that. We do them with all of ours.
Okay. Now, it's fair to say that there was a massive amount of evidence uncovered in this case.
Yes. Imagine we estimated approximately 1,700 people in the school that day. They weren't using their lockers. There was backpacks, cell phones, just dropped in. Obviously, they were worried about their safety. So we just had a lot of evidence within the school, not counting, evidence at the different hospitals from victims, the shooter's home, things of that nature.
Okay. Judge, may I approach the witness?
Yep.
This is Exhibit 1. We have stipulation.
Yes. Your Honor, we would stipulate to exhibits 1 through 4.
1 through 4.
1 through 4, thank you.
1 through 4 admitted.
Sir, I'll just give you all these right here.
Okay.
One is on top.
Yep.
Can you tell me, please, what I've just handed you?
These are the autopsy protocols for the 4 deceased victims.
I just want to make sure that's
Yeah.
all. Okay, thank you.
Sir, tell us, you've reviewed the autopsy protocols in this case?
Yes, sir.
Do you know the identities of the victims who were murdered on November the 30th?
I do.
Okay. I'm going to show you what's been admitted, stipulated to as Exhibit 418. Who is that?
That's Hannah St. Juliana,
Okay. And how old was she when she was killed?
14.
And sir, can you tell us, please, how she was killed?
The official cause and manner of death from the autopsy protocol is multiple gunshot wounds, homicide. She was shot in her upper torso, her abdomen, her thighs.
Could you refer to Exhibit 2?
I'm sorry, and her left forearm. I'm sorry.
You don't need to apologize. Referring to Exhibit 2 now.
Lieutenant, can you tell me if you know, did I promote or didn't promote you, Lieutenant? Can you tell me if you need a break.
Yes. Yeah. I'm
Okay,
sorry.
just let me know, okay?
Yep. Thank you.
Now, this is People's 419 on the screen. I'm also referring to, this has been stipulated to, also referring to Exhibit 2, autopsy protocol for Madison Baldwin. Sir, how old was she when she was killed on November the 30th?
17 years old.
And how did she die?
Again, cause and manner of death was gunshot wound to the head. Manner of death was homicide. It was a close contact shot, meaning the firearm was either on or near the victim's head when the trigger was pulled.
Referring you now to Exhibit 3. That's an autopsy protocol for Justin Schilling, is that right?
I think I have Tate years through. Justin
I'm
Schilling's
sorry.
4.
Thank you. Same here. And how old was he when he was killed?
Tate Muir was 16 years old.
This is Exhibit 420. It's been stipulated to. Tell us, please, how Tate was killed.
Again, the cause and manner of death from the autopsy protocol was gunshot wound. Tate had multiple gunshot wounds. Manner of death was homicide. Tate was shot in the back of the head at a further distance.
Now, Exhibit 4, sir. And that's the autopsy protocol for Justin Schilling.
Yes.
I'm showing what's been admitted, stipulated to for admission is People's Exhibit 421. Sir, is that Justin Schilling?
It is
How old was he when he was killed?
17 years old.
Tell the jury, please, how he died.
Justin Schilling, you'll see, you'll observe it, but he was cause and manner of death from the autopsy protocol was gunshot wound to the head, homicide. He was also shot at close contact to the back of the head.
Sir, were others wounded and suffered gunshot wounds as well inside the school?
Yes,
Do you know their names?
I do.
Can you tell us who they are, please?
There's Phoebe Arthur, Elijah Mueller, Kylie Osage, Riley Franz, John Asciutto, Aiden Watson, and Molly Darnell, who testified earlier.
Thank you, sir. Sir, tell us what happened when you assumed, may I approach?
Sure.
I'll take those things, sir. Thank you. Tell us what happened after you assumed the lead of the investigation. So where were you when this happened, and tell us the first thing that you did.
So the first thing I did was collect myself because I was pretty overwhelmed, and then we were determining areas of the school were had searched, and we were getting kids to the reunification point, which is I think was testified to at the Meyer. As that was happening, I made an announcement that I was handling the investigation to the 100+ emergency first responders that were in that office area that we saw earlier. And I said, if you're an investigator, come see me. And in hindsight, I don't know if it was the most efficient way of doing business because 100 investigators started walking toward me. I'd never obviously dealt with anything like that before, but partners from the ATF is where I met Special Agent Brandon, partners from the FBI, local law enforcement from all over the region, all offering help.
Okay, so was it your responsibility at that point to direct certain officers and agencies to do certain aspects of this investigation?
That's correct. They, for instance, Special Agent Brandon approached me with his partner, I believe, and said, do you know do you have the registered owner of the murder weapon? And I said, at this point, no, I did not. He's like, I'll take, let me take some information off the gun. We'll handle that. We'll track that down for you. And he did that, and I saw him, or I heard from him a short time later, where he advised the gun was registered to James Crumbley.
Okay. And you discovered that weapon was purchased on November the 26th, 2021 by Mr. Crumbley?
That's right. Just a few days prior on the Black Friday before.
Now, while you were on scene, did you come to learn the identity of the shooter?
I did.
And then was a decision made to secure the Crumbley family home?
It was. The shooter was on his way to the Oxford substation. I directed a couple of my investigators, Sergeant Joe Bryan, who you saw, to attempt to interview him at the substation. In addition, now that we knew who the shooter was, I directed detectives from the Pontiac substation. Lieutenant Marsband kind of spearheaded that part, and to go to the shooter's home to look for any additional casualties. It's not uncommon in a shooting situation where the shooter starts in the home and then goes to the school. So I was concerned about that initially.
In a school shooting situation?
That's correct.
Okay, and you had learned about that in your training?
Yeah, and just by prior school shootings.
Okay.
It's certainly not uncommon for that to happen.
And so you sent officers to that location, 112 East in Oxford?
I did.
All right. Now, at that time, was there a concern of explosives?
Yes. So, again, understand everything's happened very, very quickly. People started doing open source searches on the name.
The name of whom?
The shooter.
Okay.
And finding different things, and the internet is a very expansive place, as we all know. And there came a video from YouTube of him deploying a Molotov cocktail, which is essentially an accelerant in a bottle with some sort of ignition device, wick, if you will. You throw it, and when you throw it, it blows up, spreads, because the fuel inside it kind of spreads. So there's a YouTube video of that. There was also, and I'm sure we'll get to it, there was also a journal with written passages in it that described secondary devices, meaning, there was a concern, and again, at this point, I went back to Captain Hill and advised him, hey, look, there's a concern that there may be secondary devices in and around the school.
Okay. So when that information became known to you as lead investigator, what steps happened next?
So Captain Hill contacted the Michigan State Police bomb squad. While that was happening, I wasn't present for this, but it's my understanding a canine from the sheriff's office alerted, an explosives canine alerted on the backpack that was found in the bathroom the shooter exited prior to the shooting. So
What does that mean, an alert?
So the alert means that the dog detected some sort of explosive. Now, it could be a legitimate explosive, it could be a firearm, it could be ammunition, it could be something of that.
Okay. So what was done to alleviate this threat?
So, as I stated, Captain Hill called for the Michigan State Police bomb squad. They went in with a robot, and I have no expertise on how that works, but they determined that the bag was safe.
Okay. Now, sir, you were obviously on the scene at the school on November the 30th, 2021.
I was.
And you became aware that the Oxford High School has a number of security cameras.
That's correct.
Okay. And as the officer in charge of the investigation, did you also interview witnesses or review witness statements?
I did.
Okay. Now, as a result of that, did you learn the path the shooter took on Oxford on November the 30th, 2021.
Yes, sir.
So, can you tell us in what hallway and outside what room the shooting started?
Yeah, from the map earlier, you saw the highlighted area. That's all commonly referred to in Oxford as the 200 hallway. There's a short hallway and then a longer hallway. The shooter exited the bathroom adjacent to room 258, and that's when the shooting began.
And I'm going to show you what's already been admitted as people's 12. What are we looking at here?
So this is the backpack that the shooter was carried into the bathroom. That was examined for explosives that we found on the scene.
And what else do we see in this picture?
So you can see that there's some personal effects. There's charging cables. There's a journal. There's a book.
Okay. When we reference journal, this is what we're talking about?
That's correct.
Okay. Now, what of note was discovered on those pages of paper? Not in the journal, but the other pages.
Yeah, so there was over 90 loose leaf papers you can see right there. They're different assignments or whatever, and can't hold me to it. Over 50 were had drawings of firearms on them.
Now, sir, did you have the opportunity to review that handwritten journal that's depicted in People's 12?
Yes, sir, I did.
Okay. Describe what that journal is.
So the contents, sir, or describe the journal?
Both.
So the journal was a hardbound leather type journal. Should be in there. You might be able to cut it open there. It was there was approximately 22 pages of written information in the journal. It appears from some of the dates that it was written from the back cover to the front. The earlier dates seem to be on the back side, if that makes sense to you. Like I said, it was about 22 pages total in length.
Judge, I'm going to mark this for demonstrative purposes only as exhibits, so the record's clear. I believe that's 428, again for demonstrative purposes.
I'm sorry, may I please take a look at it?
Yes.
Is that just
It's just
the whole thing?
the hard copy journal.
Okay, thank you.
Yeah. Thank you.
So that black notebook you're holding in your hand, that's what's depicted here in Exhibit 12 that I'm magnifying.
That's correct.
Okay. Now these papers that we just talked about, we said over 50 with different pictures of weapons. There's no evidence that was ever turned into the school. Is that correct?
Yes, I have no evidence of that.
Okay. And you've had the opportunity to read the entire journal?
I have
Okay. Out of that notebook, how many pieces of paper have actual writing on it?
22.
And does one of those 22 pages include just a drawing and a quote from a book?
Yes.
Okay. Now, out of the remaining 21, how many reference the school shooting?
Every single one.
So there are some that have been admitted, some portions of that. I'm going to go through those with you. Just so you're aware, we've numbered them to keep them straight for you as well as the jury. Number 1 is the drawing, page number 1. Page 22 would be the back cover of that journal. Is that clear?
Yes.
Okay, and the back cover of the journal has actual writing on it as well.
Yes.
Okay.
I'm sorry,
This is exhibit
4
Yes, 401.
Are you gonna go through?
Only the ones that have been submitted.
I understand, 401.
They're all 401.
Oh, they're all 401. I
Correct.
see, thank you.
Correct.
You said individually, so I got confused.
Okay, so this has been admitted as page 401. Sir, in reading the journal, were there passages in there indicative of a request for mental health help?
Yes.
Can you read what's been identified here as page 6 of that journal?
Yes, the shooter writes, I have zero help, as you can see on hold, for my mental problems, and it's causing me to shoot up the fucking school.
I'm going to move on to page 5. Can you read this passage, please?
In this one, the shooter writes, I want help, but my parents don't listen to me, and I can't get any help.
Now, this is page 19. Can you read that?
Yes. Shooter writes, my parents won't listen to me about help or therapist.
Sir, in that journal, were there entries about the shooter's desire to obtain a 9mm handgun?
Yes.
This is also Exhibit 401, page 22. Could you read those quotes, please?
Yes. The shooter writes, I want to shoot up the fucking school so badly. Soon, I'm going to buy a 9mm pistol.
Sir, were there any passages regarding the shooter's plan for the actual shooting?
Yes, there were.
Okay. Here's page 3, also Exhibit 401. Could you read that, please?
Yes. Shooter writes, I'm about to shoot up the school and spend the rest of my life in prison.
Were there any journal entries about the shooter's access to the 9mm handgun?
There were.
This is also Exhibit 401, also page 3. Could you read that, please?
Yes, sir. The shooter writes, first off, I got my gun. It's a SP 2022 Sig Sauer 9mm. Second, the shooting is tomorrow. I have access to the gun and the ammo. I am fully committed to this now. So yeah, I'm going to prison for life, and many people have about 1 day left to live.
Thank you, sir. Now, is the journal written in normal size fonts, or are there certain passages that are bolded and larger than normal size font?
Both.
Okay. And were there drawings in there as well?
There were drawings.
Okay. Were the drawings small or were they large?
Yeah, there were large drawings.
Okay. What's an example of a large drawing?
Yeah, so there was a large drawing in the journal of a firearm being pointed at the back of a presumably a woman's head. There was a drawing depicting a 9mm caliber round versus a .22 caliber round. Those types of pictures were found in the journal.
Okay. And on the cover of the journal, what does that say? The actual cover of the journal itself?
It says apartments.com.
Okay. You said you've seen the Oxford High School security footage that depicts the actual shooting.
Yes, sir.
Judge, we're going to introduce that now. This is Exhibit 402. It's been admitted. I would like, if the court could instruct the media not to play that.
Yes, the media has agreed, and I'm going to request that the media not play, show the video in the school. That's surveillance footage of November 30th, 2021, and is People's Exhibit 402.
402.
And the victims who are present are aware of the content of this specific video.
Yes,
correct?
Judge.
All right, go ahead.
Before we get started, tell us please what this view depicts. What hallway?
Okay, so if you can recall back to the highlighted areas of the school map, this is that short hallway. The shorter portion of the long, it's all of the 200 hallway, but it's the shorter portion of the entire.
Can I stop you for a second? Are you okay if the audio is on still?
There's no audio.
Well,
is audio?
there's streaming in the courtroom, and there might be audio from the news camera, so I just want to make sure that there's no objection.
That's fine. There's no audio of the video. Is what I
Okay,
meant.
right, okay.
Okay, so this is the short portion of the 200 hallway?
Yes, and the bathroom that you see right there by the drinking fountains is the one that, correct. That's where the shooter will go into and then emerge from and begin his shooting.
And that's where that backpack was found?
Yes, sir.
Okay, so this doorway here would be the doorway to classroom 258.
That is 258 there, yes.
Okay. And just so the record is clear, this video begins at, it's 12:46 p.m.
Yes,
and the actual shooting began at 12:51.
51,
Okay.
correct.
I'm going to play right now. Again, this is 12:46. Tell me if and when you see the shooter walking down the hallway.
Okay. He is behind the young lady in the red sweatshirt right there. He's about, yep, with the mask on, the black shirt, and the gray sweatshirt.
Okay. And that's with his backpack over his shoulders?
That's right. Yes, sir. And he's going to make a right turn into the bathroom here.
So we have a split screen at this point, and that's
That's just a
picture.
camera angle from the other hall, or from the same hall facing the other way.
Okay. Okay. We're stopping at 41 seconds. Identify who you see in this video.
So that's the shooter. If you want to, the two. Yep, that's Phoebe. On the left there is Phoebe Arthur. To the right is Elijah Mueller.
Okay.
This is John Asciutto. So these four young ladies here in the Carhartt or the brown jacket is Kylie Osage. Directly across from her is Hannah St. Juliana. This is Riley Franz in the pink backpack, and across from her is her sister Bella Franz.
Okay.
At the very end, you can see the beginning. That's Madison Baldwin walking up the hallway.
And this is at 12:51 and 12 seconds on November the 30th?
That's correct.
the officers have to run past Madison, Anna, and Kylie.
In our training for active shooters, we were trained to respond, drive up right to the door if you have to, and go in, search for stimulus, meaning sounds, gunshots, or whatever. Run to that and eliminate the shooter. Stop them, however you can. Because the situation was active and the killing hadn't stopped. You can't stop and render aid. I know
Take a break, please.
if I could just finish this part, I'd appreciate it.
I'm sorry.
No problem.
Your friend's having a hard time. He's having a hard time.
I know those officers. And that is the hardest thing they're going to do in their life.
We take a break, Jeff.
Yeah, we'll take a 10-minute break.
All rise for the jury.
victims and family of victims using the restroom in the hallway, and apparently a juror was in the same restroom as a juror walked out. There was no communication, no words spoken. I just wanted to place it on the record.
Okay, no, I appreciate that. We, at one time, I mean, I don't want to tell you the inner workings of, we have 2 jury rooms going here, we've had personality issues, we have privacy issues. There are 4 bathrooms there, so, okay.
Thank you. I just wanted to make.
No, I appreciate that. It's, that's why I don't want them going to the cafeteria. Okay. Ready for the jury?
Yes, sir.
All rise for the jury.
All right, you may be seated. Lieutenant Willis, you are still on the roll, all right?
Yes, Your Honor.
Go ahead, prosecutor.
Thank you. Sir, you mentioned earlier that you directed officers to the Crumbley family home at 112 East in Oxford?
Correct.
Okay. And approximately how far in distance is that home to the school?
A mile.
Okay.
Yeah.
And as officer in charge and as a sheriff's office employee, you're aware that vehicles have in-car recording capability?
Yes.
Okay. So I'm going to show you what's been, I believe, stipulated to is Exhibit 341. This is an in-car video of Deputy Zajak's marked patrol car. That's 341.
I'm sorry, I'm just.
Was that admitted through Joe Bryan or not?
No, just 342 was.
And
342.
I'm sorry, we have no objection to 341.
Right, 341 is admitted.
And, sir, so we're clear, the deputies arrived at 112 East at 2:48 p.m., 2:49 p.m.,
Yes.
and that's November the 30th, 2021?
Yes.
Okay. And as we saw in the video, the shooter was taken into custody at 1 p.m.
Yes.
Okay.
Correct.
Just want to get the volume turned up.
Right now, why is she in handcuffs? Can you take the handcuffs off of her, please? Okay, plug in first. You can make it. It's not gonna be long for those handcuffs, I promise.
Why am I even cuffed though? It hurts, like it really hurts.
Wow, what's that?
Why am I in cuffs?
I don't know. I don't know. I asked them the same fucking thing.
They didn't do anything. I'm getting claustrophobic. I'm getting claustrophobic.
I mean, don't freak out in front of the cops. This is going to be a lot better if you don't make the situation.
Why are they here? Why are they here? Okay, can you push my glass in my nose, please? Put chapstick on my lip, please. I'm gonna get my fucking phone. Why are I'm so confused?
Why are you in fucking handcuffs?
You're going here?
I said it down, and then I have a cop pointing the gun at me.
Why are they in our house? I'm so confused.
We're dealing with this shit, already dealing with shit, why have we gotta deal with this?
Where's your gun?
In the gun case,
Where's that at?
in the transfer.
There's Patrick! There's Patrick! 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 Patrick!
He can't hear you, Jay.
Patrick!
He can't hear you. He's not gonna be able to hear you.
Patrick!
Jen, he can't hear you.
Out his cuffs.
Honey, I love you, in case something happens. If anything happens, you do not answer any questions without a lawyer.
Ma'am, I didn't catch you yet.
It's Jennifer.
Jennifer, come on now, wait, handcuffs. Take the handcuffs off.
So, sir, that video started at 2:49 p.m. November the 30th. This was after they had spoke with Sergeant Joe Bryan at the Oxford substation, correct?
Yes.
Okay. And the video that we saw with Sergeant Pesky, that occurred directly after this.
That's correct.
Okay. So when she was taken out of the vehicle, she was placed in a different vehicle, and that's where Sergeant Pesky spoke with her.
Correct.
Okay. And then as Edward Wogrowski testified, they arrived home from the location data at 2:30 p.m. after the substation.
Yes.
Okay. Sir, do you know the date in which Jennifer Crumbley was charged?
December 3rd.
Okay, so the shooting happened on Tuesday, November the 30th. December 3rd would have been a Friday.
That's correct.
Okay. And,
I believe it was noon, around noon.
okay. Tell us what happens when someone is charged with a felony in the state of Michigan. The process to actually have the charging document.
So the prosecutors give me a warrant. I go in front of a judge and I swear to the facts of the case. The judge authorizes the warrant.
Okay. And that's what we commonly refer to as a swear to?
Swear to, correct.
All right. And that happened in this case?
It did.
Is that a closed proceeding or is that open to the public?
It was open.
Okay. in fact, it was broadcast at that point.
There was media present for that, yes.
Okay. And Jennifer and James Crumbley were not in custody at the time of the swear to, is that right?
That's correct, they were not.
We've already heard from Dave Hendrick about the fugitive apprehension team in that part of the investigation. Tell us, please, how retired Sergeant Hendrick's team got involved.
So, upon being made aware that charges were coming, we knew that they weren't at the residence. So I had Sergeant Hendrick, who worked for me, deploy the fugitive apprehension team to locate the suspects.
Okay, that's purely a law enforcement function. Would that be correct?
100%, yes.
Okay, so as a detective lieutenant in charge of all of these different divisions, that includes the fugitive apprehension team?
Yes, sir.
Okay. So the decision then would have ultimately been yours.
Yes, I told him to go attempt to look for him.
Okay. Now was that on Friday the 3rd, or was that prior to Friday the 3rd?
I don't recall.
Okay. He testified yesterday that he recalled it being Thursday the 2nd. Is that accurate, or you just don't remember?
Yeah, I don't. I think it's accurate, but I don't remember it specifically.
Okay. That's fair. Now, during the course of your investigation as the officer in charge, did you learn where the defendant went after her phone was seized in the evening of November 30th, 2021?
Yes.
Okay. And I guess as a reference point, Lieutenant Sam Marsman testified yesterday as to the date and time when her phone was seized. You were here for that testimony?
I was.
Okay. So I'm going to have you walk us through that timeline.
Okay.
Now, we've heard about the track phone purchases. Did you discover where those purchases were, where those purchases occurred?
Yes, at a Walmart in Lapeer.
Okay. This would be exhibits. This is exhibit 404. I don't believe we have an objection.
Any objection to 404?
No.
404 is admitted.
Okay, so this is a photograph of the exhibit. What are we looking at here?
This is the purchase receipt for the track phones from the Walmart in Lapeer.
Okay. And did you learn where they stayed that night?
They stayed at a hotel in Lapeer.
Okay. I'm going to show you exhibit 405. I don't believe there's an objection to 405 either.
No.
405 is admitted.
Thank you, Judge. This is 405. What are we looking at here?
This is a receipt for the overnight stay at the Holiday Inn Express in Lapeer.
Now, did you do the swear-to for the shooter as well in this case?
I did.
Okay. And when did that occur?
That was it was on the December 1st. I want it. Time was sometime in the early afternoon.
Okay. If I said 3:51 p.m., would that sound right?
Yeah, that sounds about right.
Okay. Do you know where James and Jennifer Crumbley were then?
Yes. It was a swear-to, much like we do typically, open to the public. They were I believe they were on Zoom in their vehicles.
Okay. That proceeding's open to the public, is that right?
Yes, it is.
I'm going to show you. Well, first, let me ask you, did the investigation uncover where they stayed the day after the shooting, December the 1st, 2021?
Yes, it did.
Okay. This is exhibit 408.
No objection.
408 is admitted. 407 is not.
They skipped.
Correct, Judge.
Okay. Thank you.
Instead of renumbering all the exhibits, we thought it.
Oh, no, it's all right. I just want to make sure I was keeping up.
Thank you, Judge. 408, what are we looking at here?
This is an extended stay in Auburn Hills.
Okay. And this is where the defendant and her husband checked in December the 1st, 2021?
That's correct.
Does it indicate a checked out date?
December 3rd, 2021.
Okay. And that's that Friday?
Yes.
Now, we heard from Sergeant Hendrick, retired Sergeant Hendrick, that they recovered a vehicle belonging to the Crumbleys in Auburn Hills.
They did.
Okay. Is this the location where that vehicle was recovered?
It is.
Okay. This is Exhibit 409. Photograph.
No objection.
409 is admitted.
Okay. What are we looking at here?
This is one of the two vehicles owned by the Crumbleys, backed in a parking spot at the extended stay in Auburn Hills.
Now, during the course of this investigation, were banking records from the Crumbleys obtained?
Yes.
All right. Specifically on December the 2nd, so that'd be the Thursday, did you find that they had withdrawn cash on multiple occasions?
Yes, they did.
This is Exhibit 411. I believe this is covered under stipulations as well.
I'm sorry, did you say 411?
411, yeah.
That's not 411.
No, the next slide. I didn't want to publish it until you confirmed it was stipulated to.
Yes, it is.
Any objection to 411?
No objection, sorry.
411 is admitted, and again, 410 was not.
Correct, Judge.
Previously.
Yes, thank you, Judge. Okay, what are we looking at here in Exhibit 411?
This is a withdrawal of $2,000 withdrawal transfer, $2,000 from Flagstar by Jennifer Crumbley.
Now, Edward Rogowski told us about replacement phones. Did you uncover that James and Jennifer Crumbley, after buying their track phones, bought another set of phones?
Yes.
Okay. And do you know the date and location where that happened?
That was in Owasso.
Owasso, Michigan?
Yep.
Okay. And that's on December the 2nd, 2021?
I'm sorry. Yes, it was on December 2nd.
Okay. This is going to be 413, the T-Mobile receipt.
No objection.
415 is admitted.
Yes, it's just 413, correct. All right. And so what are we looking at here?
This is the purchase of the two replacement phones.
Okay. And that was Owasso, Michigan, on December the 2nd, 2021?
Yes.
Okay. What's the relative distance from Owasso to Auburn Hills?
It's about an hour.
Now, did they obtain more cash in this time frame?
Yes, they did.
Back to the banking records. This is 411. No objection to this. I believe we stipulated to this. Is that correct, Counsel?
Yes.
Yeah.
411, okay. This is Friday, December the 3rd, 2021. And what is the withdrawal amount of cash in this exhibit?
$4,000.
Now, was evidence uncovered in the investigation that showed you a transfer or withdrawal was made from the defendant's son as well?
Yes.
This is Exhibit 414. Again, it's covered under stipulation. Move to admit.
You have any objection to 414?
No objection.
414 is admitted.
Thank you. So what are we looking at here in Exhibit 414?
So this is the Simply Kids savings account, Ethan Crumbley's account.
Okay. And specifically on November the 30th, 2021, do you see a withdrawal from that account?
Yes, there was a $3,000 withdrawal that day.
And November 30th, is that significant to you?
That's the day of the shooting.
Okay. And how much was left in her son's account?
99 cents.
So what we can tell from the banking records and messages, at this date and time, the defendants obtained $6,000 in cash, $3,000 transferred from their son's account, and they were attempting another $5,000 from horse sales.
That is right. Yes, sir.
Now, do you know where the defendant went after after she checked out of the Auburn Hills motel?
They traveled to the address in Detroit, the warehouse.
Okay, and that's the address that William Creer testified to yesterday, 1111 Belleville?
Oh, yes, correct.
So I'm going to show you portions of that exterior surveillance footage that was obtained. Before we do, we've already talked about the timestamp difference. The timestamp on the video is about 22 or 23 minutes fast. Is that correct?
Yes.
So these will be, we marked them separately for convenience, as 415 and 416.
Okay.
And the people will move to admit and publish now. We'll start with 415.
Any objection to 415 and 416?
No objection to 415. There is an objection to 416 because Mrs. Crumbley is not a part of it.
Judge, I think it is relevant to show what happened with the vehicle and why, especially in light of Mr. Kirkley's testimony yesterday. and Mr. Creer's testimony yesterday.
Your Honor, it doesn't involve Mrs. Crumbley, so I would object.
I think it's relevant to their activities, and it's non-testimonial. I'm going to admit it for
Thank you,
16.
Thank you. Again, I'll start with 4:15. Before we hit play. Again, the timestamp is 11:20 and 35 seconds on November the 3rd. I'm sorry, December the 3rd, 2021.
That's right.
Okay, so actual time would be approximately 10:58 a.m.
Correct, sir.
Okay. What do we see here in the video at the 11:21 timestamp?
Yeah, so that's the a friend of the defendant who activated the security gate to open it, and the defendant pulled in and parked.
Okay, and again, this is the parking lot at 1111 Belleville in the city of Detroit.
Yes.
Tell me if you see anybody you recognize.
I recognize the defendant.
Maybe this person right here.
Yep. Yes.
And your friend you identified as this individual.
That's correct.
Is James Crumbley depicted in this video as well?
Yes, that's James there.
Right here in the magnified portion?
Yes.
Okay. Okay, now I'm going to play you 4:16. Before we start again, the timestamp is 16:10. First of all, what is $1,600?
That's 4 o'clock in military time.
Okay.
4
And,
4 p.m.
and this would be, so shortly before 4 o'clock actual time on Friday the 3rd.
Yeah, 3:48, I think, or something like that.
So this is about 4 hours after the charges were officially announced? Is that
That's
right?
correct.
Okay. And about a day or so after the fugitive apprehension team began looking for them?
Yes.
Your Honor,
When charges?
Your Honor, I would object because this witness is saying no on the fugitive apprehension team. They came to my office on Friday.
Hold on,
And so
hold on,
he
hold
would-
on.
Wait, okay.
He wouldn't have personal knowledge of the fugitive apprehension team, and he's saying the wrong date.
Judge,
Okay, well-
counsel can't insert that.
Well, you can't testify, but I want to know from his personal knowledge. You know, one thing I think that would be helpful is, I don't think, would I even refresh your recollection about when the swear to was? 'Cause it-
The swear to for, we mentioned two, Your Honor. So you talking about the swear to for the defendant?
Yes.
The swear to for the defendant was the December 3rd.
December 3rd.
December 3rd.
Okay.
Right.
So when did you contact the fugitive apprehension team?
December 2nd evening or late afternoon, evening time to get an idea where the defendants were, because we believe charges would be forthcoming.
But they said that he said they came on the
You
3rd.
mean Hendricks?
Yeah, and Hendricks came to my office on the 4th.
No.
Okay.
Hendricks, Friday the 3rd is when Hendricks testified that he showed up there. He was conducting surveillance prior to noon.
Oh, he was there without me. Okay.
It's all on the record.
Okay, yeah, you have to rely on the evidence from the witness stand, okay? And you have to rely on your collective memories and your notes, right? Go ahead.
Thank you. Okay, sir, you testified earlier that the swear to that was broadcast was noon, Friday, December the 3rd.
Yes.
Okay, and this video is around 4 p.m. Friday the 3rd.
Correct.
Okay. Now, Luke Kirkley testified about looking at a poster online, and that's what spurred him to call 911. Do you recall that?
I do.
Okay. And so when a BOL or be on the lookout is announced, is the license plate of a vehicle also given?
Yes.
Okay. Was the license plate on this vehicle in the front of the vehicle or the back of the vehicle?
It was affixed to the back.
Got it. Now, sir, Mr. Bobrowski already testified about the location data for Jennifer Crumbley on the day of the shooting, November the 30th, 2021. Do you recall that?
I do.
Okay, and as officer in charge, you're aware of that information that he uncovered?
Yes.
Okay. Just want to confirm that Jennifer Crumbley never stopped by her home at 112 East after meeting Mr. Hopkins at the Oxford High School?
No, she went directly back to work.
Okay. Now, you've had the chance to review phone logs as well as other information from social media and information obtained from Jennifer Crumbley's phone.
Yes.
Okay. And sir, do you have any experience getting someone same-day mental health help?
Yes, I do.
Are there facilities available for that?
Yes, there's a facility on this complex called Common Ground that's available for that.
In reviewing the phone logs of Jennifer Crumbley, is there any indication of any phone calls to a facility of that sort?
No.
In fact, any phone calls to any doctor's offices?
No.
Counselor offices?
No.
Any hospitals?
No.
Okay. Any mental health professionals at all?
No.
Thank you. I have nothing further.
Cross.
Okay, thank you. Sergeant Willis, I want to go back to the pages from the shooter's journal that were admitted. You don't have any evidence to suggest that Mr. or Mrs. Crumbley ever saw the journal, correct?
I'm sorry, miss.
You do not have any evidence to show that Mr. or Mrs. Crumbley ever saw the journal.
I'm sorry. It's been a tough day. Okay. So you're asking me do I believe Mr.
No.
or Mrs. Crumbley?
I'm asking you.
Do I have evidence?
Do you have any evidence to believe that Mr. Crumbley or Mrs. Crumbley saw the journal?
No, if I had evidence of that, I imagine the charges would be different.
If you had evidence they saw the journal, the charges would be different?
Yeah, murder.
Okay.
I would imagine.
Okay, so the journal was located in the backpack that belonged to the shooter,
Yes,
correct?
correct.
There were also a number of other papers in that backpack that you described.
Yes.
You don't have any evidence that Mrs. Crumbley ever saw any of those papers, correct?
Correct.
Now, in the journal, you've testified about certain statements the shooter wrote in the journal, correct?
Yes.
And specifically, one of the statements that you testified about was where the shooter wrote, "I have access to the gun." Is that correct?
Yes.
In the journal, there are other statements where he indicates he is looking for the gun, correct?
Can you tell me which ones you're referencing?
Sure. So I'm going to hand you, Your Honor, may I please approach?
Sure, just show Mr. Keystridge.
Sure.
Yeah.
I have a copy of it too, if that helps.
Judge, just briefly, this was subject of a prior court ruling.
Yes. So I'm
And-
gonna ask everybody to be really careful. All right?
Okay, so I was going to show 788, just this one line.
Okay, again, Judge, maybe we should have a minute outside the presence of the jury.
Your Honor, can we just approach and I can show you?
I have it, and I know
Do you want
exactly what it is.
to? Do you want
No,
me to-
it's not that. We have to discuss the court's prior ruling.
Your Honor, I think, okay.
All right, I'm going to excuse you for 10 minutes, all right?
All right, for the jury.
You can stay there or step down, however you're comfortable.
I'm fine here, Your Honor. Thank you.
I'll be brief, Judge. The court is aware where I'm going.
I am well aware.
Yes. So and the court rules specific passages to be admissible under specific portions of the hearsay exception
Okay.
in response to defendant's request to exclude the entire journal. I don't want to speak for what counsel's doing, but if counsel is going to admit other portions that have already been ruled to be inadmissible, that's something that has to be discussed on the record, and I think it's something that has to be ratified, Judge.
Well, I am, of course, going to warn everybody about opening the door because this journal is obviously very, very disturbing. However, if when you put the black robe on, you can read people's minds. So I'm assuming that Ms. Smith is seeking to admit on page 788, I don't know where my dad hid it.
Yes.
And also on page 795, where he says, I have to find where my dad hid the 9mm. Isn't that what she's seeking to do? Are you
Yes.
seeking
That's
to
what it
do?
looks like.
That's correct.
Are you seeking to do anything beyond that? Be specific, because
There's,
I can't unring the bell, right?
that's correct. I'm seeking to do those two with the claim about access to the gun. And the detective also testified to a statement about I'm going to get the gun. So I wanted to impeach him with, on 789, there is a statement that says, it's one line, however, I don't want to be caught as that will make me getting the 9mm impossible.
It's not impeachment because he's not the declarant.
Well, I'm hamstrung because these statements are coming in by a declarant that I'm not allowed to call as a witness. And under the
Okay,
same...
well, I want to back up a second. I never said that you could not call the shooter as a witness.
I was getting the vibe that would be the ruling of the court.
No, that'll never be the ruling of the court. I'm not telling you that you can't. I am not, as a judge in this court, telling you you cannot call the shooter as a witness. However, we've been over this before. We're going to go over it again this afternoon. Pursuant to case law that everybody's aware of, including a case called Jackaloni. It's 399 Mich 642, a 1977 case. No one is allowed to put a witness in front of this jury who was going to take the fifth. No one. It's not me.
Well,
I'm not keeping you from calling someone as a witness. but his Fifth Amendment rights have been asserted repeatedly. And I can't let you put a witness on the stand, anyone, the prosecution too. I wouldn't let the prosecution put someone on the stand, knowing that that person was going to take the Fifth Amendment, take the Fifth. If someone takes the Fifth in front of the jury, it's over. It's a mistrial. I can't let you do that, right? And I also asked before, aside from what is your favorite color, I can't imagine something you could ask the shooter that would not implicate his Fifth Amendment rights. His current attorneys, the State Defender's Office, have asserted his rights. They've said he will not testify.
I understand that. I have said I would still like him to testify, so I just need a finding by the court that under case law he's not going to testify.
I'm not making a finding that he's not going to testify. His lawyers have asserted the Fifth. You're not allowed to put someone on the stand that will take the Fifth. And in reality, if they say he won't testify, I don't know what am I going to do? I'm going to insist that he testify and then hold him in contempt and put him in jail? Is that?
Well, Your Honor, I understand the court's position, but for the record in this case,
and by the way, I understand your position as well.
I've indicated,
I do.
For as far as our position, I've indicated I don't believe the shooter should be allowed to plead the Fifth because he was sentenced. He's made statements about the crimes. He pled guilty to all 24 counts in adult court, and so I don't.
So
believe
you think that's over? Do you think that's over?
Well, I think there is not case law that says he gets to continue his Fifth Amendment rights beyond that plea. I don't disagree with you.
His appellate rights?
He's going to pursue an appeal. I don't disagree.
All right. So, what would make me think he does not still have Fifth Amendment rights?
There's case law directly on point.
I know, and some of those are indicated in the letter provided by the State Appellate Defender's Office, right?
Yes, sir.
Yeah. I understand your position. I also understand, to a certain extent, I don't, even if he was called as a witness, you understand that then the prosecution would have a right to cross-examine him, right? So, I'm not keeping you from calling him. The law is keeping you from calling him. You are not permitted to put someone in front of this jury who is going to take the Fifth.
I understand.
Yes.
That's the ruling then. That the law doesn't allow me to. Is that correct? Okay.
By smarter, higher courts than this one.
If that's the ruling, is that the court is going to follow the law the court said.
I'm going to follow the law.
Then I've preserved the record and I'm moving on.
Okay.
So then these statements are coming in. They've come in as present sense impressions.
Okay.
And I'm not using them at all for the truth of the matter asserted because I don't know whether he found the gun or didn't find the gun or was looking for the gun. But this statement shows his state of mind, so I believe it falls under the exception, saying he doesn't want to be caught because it will make him getting the gun impossible. So his state of mind is not wanting to get caught. And that's important impeachment to the testimony from the detective that he said he was going to get the gun.
Okay, so are you addressing that statement or also there's the, I don't know where my dad hit it, and there's a statement, I have to find where my dad hid the 9mm.
The two hiding ones are one issue, and then the second issue is I don't want to be caught.
All right, and
that's it.
okay, do you have any legal support for that? Just present sense impression.
And just straight impeachment rules.
Again, impeachment doesn't apply here. Impeachment is if a witness he didn't make the statement. I mean, that's not in dispute. It's not impeachment.
I can impeach through other witnesses. I can impeach by omission. I believe under straight impeachment rules, I can use this. This is being admitted as substantive evidence. So I can impeach with something written on a napkin.
Okay, but I guess what he's saying, and this came up too with regard to the privilege records,
correct,
which we'll talk about again. who are you impeaching though?
I'm impeaching the shooter's statements that have been deemed substantive evidence. And I'm not given the option to impeach through the shooter, so I'm seeking to impeach through the officer in charge.
Okay, so why wouldn't I allow those statements, Mr. Keith?
It's not permissible. It's not under, and council has not cited the rule for that. It's not permissible. And I just want to inquire of the court if council is permitted to do that. Am I allowed then to ask about other passages?
Well, that's what I'm concerned about.
I mean, there are
How
a number
do
of,
they relate to this?
I mean, just in the first 2 pages alone, Judge, we have if they see the picture of the gun on Instagram, we'll know what's up. We have,
Yeah, all of these things, all these things, with exception of the period of time that I was stayed by the Supreme Court, to me could have been addressed, so this sort of doesn't feel like the time to be doing this. But
Earlier in the trial, when I found that the court wanted to know what objections were going to be made, I stood up and said, I know this is going to be an issue, and the court said, we'll handle it down the road in trial. I made the court aware of that. That was on Monday or Tuesday, when there was some friction about another objection. I said, this is going to be coming, and the court said, we'll cross that bridge when we come to it.
okay, because I guess my position is that we should have crossed that bridge before we impaneled a jury. That's just,
Judge, we put the passages the court specifically ruled as admissible, nothing more.
okay, but why would her request to allow those 3 passages because they're a present sense impression?
Well, I don't necessarily agree there's present sense impression because there's certain requirements for present sense impression as well as state of mind. We can't be talking about a future plan. And there's Brady, his friend is gone, he has no friends. My wrist hurts from writing in this, fucking book so much. I haven't felt generally happy in years. I can feel the evil around me, even dogs sense it. I mean, that's just on page 5.
That doesn't impeach, though, anything that I'm using, and the prosecution didn't seek to admit those things. I also didn't...
We've only admitted what specifically would be covered under the rules that the court permitted us to over a year ago.
Yeah.
We're not trying to push the envelope here because, as the court is, we don't want to inject any kind of error, Judge. So we kept this extremely close to what the court has specifically authorized.
Well, which provisions specifically you say are present sense impression? Because I don't know that they are. I don't know that they are. On page 788, I don't know where my dad hit it.
I'm finding the provision right now.
It's just, my concern is more along opening the door. Judge.
Yeah, that seems to be the thing.
I don't believe that what I'm asking is opening the door to all the texts coming in. I believe my impeachment is very limited. It's limited to 3 sentences.
Okay.
And then
Okay, you're operating under 803.
under 803, and let me just
8033 is then existing mental, emotional, physical condition. Has to be then existing mental, emotional, or physical condition.
I think that's a then existing.
I have a headache. I feel sick. Right?
It also says such as intent, plan, motive, design, and So his plan to give puppy eyes or whatever, I mean, his plan to not give puppy eyes, I'm sorry. His plan to act in a way so he's not caught, I think does fit under the rules. Because it talks about intent, plan, motive, design, mental, feeling, pain, or bodily health.
So here's the crux of the issue, is that for a year and a half, we had just those 5 or 6 portions admissible by the court. This trial was prepared from the prosecution standpoint with just those admissible because the court was very specific in its ruling. And so now defense is using that ruling as a sword and a shield. And so if the court wants to make a substantive ruling mid-trial, I think I'm entitled to at least a minute to
not.
Your Honor, I'm the one that filed the motion that brought this issue up. I filed an appeal with the Court of Appeals.
I'm aware.
Okay. I got their exhibits after trial started, identifying these portions of the journal.
Okay.
That after trial started.
You've had this journal as have I.
Absolutely.
For a long time.
I have, and that's
why.
why I filed an extensive motion about it. But now that they're using bits and pieces in trial,
we used only that was identified on June 27, 2022.
it shouldn't preclude me from impeaching.
Okay, but that's what I'm going back to. Who are you impeaching? What rule allows you to impeach someone who's not testifying?
It's complicated because I can't impeach the person that I want to impeach through testimony. So you're right. I'm hamstrung. My client has a constitutional right to present a defense, though.
I'm aware of that.
And I'm getting hamstrung and stuck because of other extraneous legal issues. This is straight impeachment. So what I'm providing is not going to be admitted as substantive evidence. It's impeachment.
So she's being hamstrung by her own motions to exclude. Her own motions to exclude. We didn't move to exclude any of this evidence. Counsel did after the preliminary examination, and this court was specific in its ruling.
Well, there should have been a motion to include as well, as what they're saying.
There's no rule, there's no requirement for anybody, any party to have a motion to include, especially when counsel specifically identified this piece of evidence as being inadmissible. The court made the ruling.
Well, I guess what I'm saying, if you were in fear at all that this court would rule incorrectly, you would still have an opportunity to appeal that ruling.
And we didn't appeal the ruling. We didn't appeal.
Your Honor, I would have filed a motion if there was substantive information additionally that I wanted to admit. I've never filed a motion to have the ability to impeach. I'm asking to impeach. No one files motions to say, may I impeach this?
Because this is the third time during the trial.
There's motions in limine with regard. This journal is very disturbing, and every time any of us have read it, we've been up all night, right? So this has been a glaring thing in this trial. This isn't a middle of the trial type of game plan here.
Right. Just so the record, is clear, because I know the court's aware. We went through the Facebook messages detailing alcohol use. We talked yesterday in depth about the extramarital affairs that were previously excluded, and now the journal. This is the third time mid-trial. We just need the ground rules. The court gave us those ground rules a long time ago. We prepared a case in accordance with that. So if the door's open, the door's open.
Okay, well, that concerns me too. I'm going to take a brief recess.
Thank you, Judge.
All right, so you can step down.
Thank you, Your Honor.
You can't discuss your testimony with anyone.
Yes, Your Honor.
Okay. I'll be back.
All right. You may be seated.
All right, I'll see you. Good, next time.
So you can drink.
Yeah, I'm good.
Just a
standing like that?
so far.
Your Honor, calling people versus Jennifer Crumbley, case number 2279990, FH.
Good morning.
Thank you. Marquis submit people.
Karen McDonald, yeah.
I'm Jennifer Crumbley.
Okay, so I'm going to have a couple questions for you. This is certainly one of the kind of things that you want to spend some time on. Initially, I want to point out that you have said you want a statement. However, I do not want to be caught, as that will make me getting the 9mm impossible. That's what you said you want. Okay, here's the problem with that. It might be a future plan, but this isn't a future plan not to get caught planning to shoot up the school. This is a future plan with regard to Jeffrey, right? Which is discussed extensively prior to this, right? Jeffrey, Jeffrey would be the bird and bird head.
Oh.
Right? So.
Oh, I see. Okay.
So there's.
That would open the door. Okay, I see what you're saying.
Yeah. So.
And of course I guess.
I do not want to be caught, as that will make me getting the 9mm impossible. He's talking about getting caught with the bird head in a jar and the terrible things he did to baby birds. So I'm pretty sure that you do not want that to come in.
Right, I don't want the baby birds to come in. I
Okay.
thought when he said I don't want to be caught, it was being caught, like having mental problems, being caught with the bird, being caught with any of the stuff he's been doing.
Okay, well,
I didn't take it to be the bird, but I see what the court's saying. You're
if
right.
read-
If that opens the door to the bird, then I don't want to open the door to the bird.
There's an extensive discussion prior to that with a picture and about him dumping the bird's head in a bathroom, and I hope people will talk about it for the rest of the day because I want the attention. However, I do not want to be caught, as that will make me getting the 9mm impossible. He's not talking about getting caught with the plan to shoot up the school. He's talking about getting caught with putting the bird head in the bathroom and hurting the birds. So I think it's pretty safe to assume that you do not want that statement.
That's correct, Your Honor.
Okay, here's I know I'm going to regret this. I'm going to let you respond to this, but I also wonder. You say you want his statements. I have to find where my dad hid the 9mm, and I don't know where my dad hid it. it's hard for me to understand what that impeaches because we just saw a video where Mr. Crumbley is telling Mrs. Crumbley, she asks him specifically where was the gun, and he says, I put it in the dresser, right?
That's the other gun. That's the other two guns.
Okay, but there's also statements to the police about where, isn't there a statement on the video to one of the police officers?
Yes, sir.
About where it was? Was that the armware one?
Yeah, where she hit the bullets, Judge, yeah.
No, she hid the bullets in the drawer with her jeans.
Okay, well, isn't there other statements in this trial about where the SIG was?
Yes, Judge. And it's
Hid.
lots of different statements. That's part of the
Hidden.
part of the case.
It says it was
Where?
hidden.
Okay.
Yeah.
All right. So anyway, the bird, Jeffrey's staying out of this.
Yeah, I agree
Okay.
with that.
All right.
And I misread that. I did not.
Okay. Well, it's hard to read, So anyway, what else do you want to say about this?
Judge, this is the people's issue here, is that well over a year ago, this issue, as well as a number of other issues that have been addressed the last few days, have been settled. It was June 27th of 22. It was appealed. The application to the Court of Appeals was filed on July the 18th of 2022. This is a pattern now that appears to be part of counsel's strategy. That's fine, but the people should be entitled to now prepare accordingly. So counsel has promised the jury that Jennifer Crumbley is going to testify. That's significant because that entire Facebook thread has come in. That's over 2,000 pages. I know from my memory there are a number of messages that will be very important at cross-examination. But because it's been sprung up mid-trial at the request for an unredacted copy of that, I want time to go through that before the defendant takes a stand so I can have every passage ready.
I'm sorry, I don't understand. You want to go through what?
The Facebook thread between
Facebook, okay.
Jennifer and James Crumbley.
Okay.
Your Honor, the prosecution moved to admit the whole thing. I have no objection. I'm ready to go with it.
Okay,
They moved to admit the whole
okay,
thing
wait.
in front of the jury. Now he's saying he's not ready for
Wait a
it.
minute. Am I missing something? I'm talking about the journal right now.
Yes, this is the pattern, Judge, the pattern of strategy. And again, counsel's entitled to her own strategy.
Right.
However, we are entitled to prepare our witnesses accordingly, including the cross-examination of the defense witnesses. We responded to the defendant's motions with the journal in particular with a select number of passages that firmly fit within the instructions provided by this court.
And that was in response to her motion on the night.
Yes, Judge, and it's the court's order, not the defendant's order. So we're following the court's order when we prepare for trial. Again, if counsel wants to reverse course mid-trial as part of our strategy, that's her decision. But we need to have the time to prepare. So I'm asking for the court to give us the time to go through that Facebook thread, as the court gave defense counsel time to go through statements of her own client's statements before Mr. Meloche testified.
Okay. You guys have gone off into Never Never Land here. I want to address the journal and then finish the lieutenant's testimony. I also want to make the sealed record during the time period that the jury is eating lunch. So at this moment, I'm going to indicate that I heard about the journal. The journal is extremely disturbing in many, many, many ways. And I do not want to risk the door being open. But more importantly, these statements, I have to find where my dad hid the 9mm and where, I don't know where my dad hid it. I don't know if that it impeaches anything in this case because there's already been plenty of evidence that he found it, right? There's evidence the shooter found the gun, right? And there have been statements made by both the defendant and her husband to police in text, whatever it is, indicating that the gun was hidden in some way, obviously very poorly, but the gun was hidden in some way. The gun, as far as we know, was not sitting on the kitchen table. So I don't think this impeaches anything. I don't think it's contradictory. More importantly, I don't think under any circumstances any more of this journal should come in. And in the event that it was going to come in, I think that it should have been handled prior to the jury trial. I am trying to very much protect any potential appellate record, and I do not want to delve into this journal. I think that would do nothing more than hurt Mrs. Crumbley severely. It's highly prejudicial. So that's my ruling about the journal. If you have other issues you'd like to bring up, I'd appreciate if we did that when the jury's at lunch after we make the sealed record.
That's
okay?
fine. If we can finish.
Okay.
it.
Let's finish him. Okay. Okay. Their lunch arrived, so they are eating it. Okay. Lieutenant, I'm going to indicate that you should not discuss your testimony with anyone because you're in the middle of your testimony.
Yes,
all right. So you can step down.
Okay.
I'm going to have. When did they start doing that? 2 minutes ago. So I'm going to indicate that they should be prepared to come back and hear testimony at 12:30. All right. In the meantime, you can step down.
Yes,
Step down.
I'm sorry, Judge.
As I indicated to both of the attorneys as well, I think I sent and had my assistant send an email. Yes, yeah. I think my assistant sent an early morning email to you about making a sealed record pursuant to Michigan Code Rule 8.119. Correct?
Yes.
It'll be brief. It'll be brief.
Yes.
All right. So because of that, I'm going to exclude everyone but the parties. We're going to do that briefly. Then I'm going to allow Ms. Crumbley to go downstairs and eat her lunch, and we're going to break until 12:30.
Just before we go off the record, I just wanted to complete the record that we were speaking.
Okay, go ahead.
So we've gone through this. I don't want to belabor the point. The issue that the people have is that it appears that counsel is trying to usurp the court's order without notice to the people, and that makes it impossible.
Okay, let's start over with this issue because I was talking about the journal and then
Yes,
you started
Judge,
telling me.
it's-
So start over. Okay.
Thank you, Judge. The journal appears to be a pattern of strategy, which is without notice, mid-witness, shifting from what the court has already ordered to what counsel chooses to be convenient. And again, if that's trial strategy, that's trial strategy. But we have the court's order, not the defendant's order. And I don't believe it is appropriate for any party to usurp a court's order. And I also don't think it's appropriate that the people will have to respond off the cuff. I want to make sure that our witnesses are prepared.
Okay.
I want to make sure the materials necessary for cross-examination are prepared as well.
Okay, so the issue right now is the numerous Facebook communications between Mrs. Crumbley and Mr. Crumbley. That's the issue. That came in.
And Your
That's
Honor,
the piece of evidence.
Okay.
Within that piece of evidence, there are a number of issues to explore.
Okay.
Within that piece of evidence, it includes items that defense counsel had previously sought to exclude, and this court did in fact exclude. So that was the discussion that we had when Mrs. Crumbley was placed on the record, and she said under oath that it was her decision upon consultation with her attorney, knowing that we could cross-examine. I just want to make sure that people are given the opportunity to review all of those 2,000 messages or 2,000 pages of messages appropriately before that cross-examination begins.
Your Honor, I just want to point out that the prosecution moved to admit the entire thing in front of the jury. So I believe if I objected, it would look like Mrs. Crumbley is hiding materials, and we've taken the trial strategy actually based on their trial strategy, bring it all in.
Okay.
And so when Mr. Keese
It was a redacted copy.
Okay, I don't
But listen,
understand. I don't
when-
understand why we're taking a trip down memory lane. The whole thing came in already.
Right, it came in, but I'm saying he asked for it. That was days ago, and I'll tell you what,
And then you agreed to it.
I did. And since that time, I've read the whole thing and I'm ready to go with it. What
Okay.
he's saying is that he's not ready to go with it, even though he moved to admit it, and even though it was days ago that he moved to
Just
admit
to
it.
correct the record, we moved for a redacted copy and for counsel to specify exactly what portions were redacted in accordance with your order,
And
Judge.
the next day I got back to them, which was days
I'm
ago,
going to ask
and
you to
I
keep
said,
your voice down because the walls are paper thin
Sorry.
and the jury could hear you.
I got back to them the day after and I said, we're not asking for any redactions. They said, fine. We made a record with Mrs. Crumbley, no redactions.
Okay, when is this going to come up anyway? How far are we going to get after Lieutenant Willis?
I guess it depends on how often this comes up. And this is why I bring it to the court's attention that
This will come up when Mrs. Crumbley testifies if she does, right?
certainly.
Okay, is that the only time?
Well, I brought up the pattern to the court's attention because it does appear to be a pattern. The only reason I bring it to the court's attention now and our objection to that is because it appears to be a continual theme. So I want to bring it to the court's attention now, and I want a record made of it. That's why I bring it up now.
Okay, well, you can't admit something and then unadmit something. There's no court rule that says you can do that, right? Okay.
No, it's the redacted portions. It's the portions within that would have been inadmissible prior to.
Yeah, I get it.
Okay.
Yeah.
And we said we still.
We're letting it all hang out.
We're letting it all hang out.
Okay.
And I don't want any redactions because I think it makes it. Mr. Keast has made it look like if we put redactions in there, we're hiding stuff.
I
So
don't
I'm
even know why
not.
we're talking about this.
We
The
shouldn't
whole
be.
record came in. It is in evidence. It is fair game. Okay? All right. That's
You're
what we're
right.
doing.
With respect to the sealed record, I just like to rely on my written pleadings.
Okay. Well, you probably are, but I'm going to make a record of those because privileged, there are privileged conversations between the shooter and a therapist in those pleadings, and I'm going to make a record about that is sealed because I am. So, all right.
Are
So
they all going?
yeah, I'm throwing everybody out. So,
Recording stopped.
But this will be on the record.
oh yes. This. Yeah.